Coming up next on Arizona Horizon, a debate on new rules for prosecutors who find evidence that a convicted defendant is not guilty. And we'll follow that debate with a look at both sides of Arizona's Stand Your Ground law. Those stories next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simon. Scottsdale today added nearly 2,400 acres of state trust land to the city's McDowell-Sonoran Preserve. This after Scottsdale proved to be the successful bidder on a $21 million purchase from the State Land Department. Today's move increases the preserve to within a few thousand acres of the city's goal of 34,000 acres. The Arizona Supreme Court issued new rules last week requiring prosecutors to reveal evidence that could prove the innocence of a criminal defendant. The new rules also say that prosecutors must take steps to have a conviction overturned if they find clear and convincing evidence that a defendant is not guilty. Here to discuss what the Supreme Court enacted is Elizabeth Ortiz, the Executive Director of the Arizona Prosecuting Attorneys Advisory Council, and Keith Swisher, an attorney and professor at the Arizona Summit Law School. Good to have you both here. Thanks for joining us.
Thank you, Ted.
Your thoughts on what the Arizona Supreme Court enacted?
Well, the rule itself has very little impact on what prosecutors will do day in and day out. We have historically disclosed exculpatory evidence. While we had some comments regarding the particular aspects of this rule, we supported the principle of the rule, and we continue to support the principle of the rule. So it will not impact day in and day out what prosecutors have done and will do.
Your thoughts?
Well, I'm happy to hear Elizabeth say that because some of the comments didn't suggest that the principle was supported, but I'm glad to hear that it is indeed still supported. The rule will, in instances where a person may have been wrongfully convicted, will make sure that that evidence is disclosed, will require prosecutors to look into it, and then if the evidence, as you mentioned, rises to the level of clear and convincing, then take steps to set aside the conviction. A wrongful conviction is perhaps one of the gravest tragedies in the criminal justice system because not only do you have the convicted defendant behind bars, but you also have the truly guilty party out there. Typically these are violent crimes, committing further crimes against the public.
My impression is that most prosecutors look at this and say these rules, this rule, the entire scope, not necessary. Why?
That is exactly it. And that was our initial reaction, was the proposed rule change wasn't necessary because we are already disclosing exculpatory evidence. We had some concerns because it appeared that the rule was targeting prosecutors for, we believe, no appropriate reason. It also, we had some procedural issues with the rule, such as it required reporting to a public defender's office where not all counties have public defenders. So there were some problems along those lines also. But we always did support the rule in principle and continue to.
Was this necessary? Because again, I'm hearing from someone on the prosecutorial side that this is a solution in search of a problem.
Right, I did see that, Ted. It is necessary to provide guidance to prosecutors in these very important circumstances. Perhaps the best argument I saw against the rule was as Elizabeth just articulated, we do this already, right? So then I can't really see the argument as to why having a rule in place to give guidance to new and more seasoned prosecutors in these egregious situations would be a bad thing. So I actually think it's a good new step for the state to have adopted the rule.
Why not require steps, though, to be taken? And operative word here is require these steps to be taken if a wrongful conviction is evident.
And there are already steps in place and have been in place for many, many years that prosecutors have been following. We have Rule 15.1, our disclosure requirement, that essentially tells prosecutors, turn over everything you have. And prosecutors do, and you know, I myself am a career prosecutor. I was with the Maricopa County Attorney's Office for 16 years, working in the trenches before I came to APAC to train and lead. I can tell you, and I still carry a caseload, this is what prosecutors have done and will continue to do. We follow Rule 15.1, we follow the case law, we follow the ethical rules.
And yet, there have been some high-profile cases here where it seems as though there was reluctance, there may have been an actual hindrance to this evidence by prosecutors. First of all, is that valid? Secondly, if valid, how common?
It's definitely occurred, Ted. I mean, I want to preface this statement by echoing Elizabeth's comments that most prosecutors are great. Right? It's not an issue about every prosecutor. The problem is one person in prison innocent is too many, and a rule like this helps to prompt the prosecutor's office to create structures to filter in the good evidence and the bad evidence, and to more promptly get the innocent person released and the guilty person behind bars.
Is there a reason? I mean, again, we've seen high-profile cases where there's evidence that could have been shown that a convicted person was not guilty. Read about it in the paper, you hear about it now and then, here and there, enough to where the Supreme Court Chief Justice said that prosecutors do have a special duty, a special requirement. They represent all of us, and thus they should be held to a higher standard. Why not a higher standard?
Well, we are held to a higher standard, and when I train prosecutors, I tell them, you are held to a higher standard, and if you don't like that, then with all due respect, you've picked the wrong part of the legal profession. So this rule has never been about prosecutors trying to walk away from being held to that standard. For us, it came down to whether or not it was necessary. Have there been a few isolated instances? Yes, there absolutely have. But I agree with Keith that they are very far and few between. What frustrates me is when those very far and few in between instances are sometimes used as a broad brush of what's going on. You know, prosecutors, that's our worst nightmare to convict an innocent person, because not only is a person who didn't commit the crime being punished, I have a victim whose hand I often held, who knew that I worked day and night to have someone held accountable, and the wrong person. And finally, I'm a member of the community. So when the wrong person is being punished, that means that a very potentially dangerous person is out there where my own family lives.
But is there, and again, the perception is that when these instances, you mentioned few and far between, when they occur, there is not an emphasis, an urgency to either address that situation or in some ways address the person who is responsible for that situation.
And that simply, with all due respect, has not been my experience. And you know, there are many examples that don't necessarily make it into the paper because the facts aren't particularly interesting or sexy, if you will. For example, in Yavapai County recently, they realized that some drug cases that they had charged that due to the particular drug being mutated, it did not fit within the very narrow statutory definition of that crime. They realized it, and they affirmatively went back and had those convictions undone. It's those types of things happen every day in prosecutor offices, but they don't make the headlines.
And yet the Supreme Court Chief Justice again wrote that prosecutors special duty, ministers of justice, and she referred to they are not advocates who seek convictions at all costs. Just that reference suggests that that is out there, correct?
Absolutely. In fact, one of the things we based the rule on was prosecutors' unique role in our criminal justice system. It's critically an important role. It's a minister of justice whose purpose is not solely to convict. So in other words, justice doesn't just stop at conviction if it turns out we have the wrong person, right? So perhaps you could lock a person up, but it's the rare instance where you could just throw away the keys and not be willing to objectively re-examine the evidence. And I would like to note too that there are instances where good prosecutors, as Elizabeth noted, do the right thing and it's not highlighted in the media. And that's unfortunate. I think that would be a good correction when that does happen. On the other hand, there are times when people, as the example in the drug case, Ray Crone, the Hall matter, et cetera, that a person shouldn't be convicted either legally or factually. When that happens, then there should be rules in place to prompt the prosecutors to take quick and effective action. And then victims were mentioned a second ago, and I'd like to highlight a couple of things with respect to victims. First of all, the only comment from victims directly in favor was a very influential victim who had been a victim of a violent sexual assault and had wrongfully identified the perpetrator. So once the real perpetrator was found, she had to not only have gone through that violent offense, but also then made amends with the person whom she had helped to wrongfully convict. And she filed a comment. She's also been an author of a New York Times bestselling book in favor of this rule. And the other good thing that the rule does with respect to victims, for the first time we are now the 9th state to adopt this rule. And for the first time, it actually includes a notification that sort of gestures towards our victims' notice laws that says if you're about to seek to set aside the conviction, you would also explicitly give notice to the victims. Now, that might happen anyway, but the rule specifically requires it now.
Real quickly, as far as can you order law enforcement? I mean, let's say that requirements are in place and there is someone claiming X, Y, and Z. What happens next? Are you able to take those steps? Can you order law enforcement to take these steps for more investigation? I mean, the logistics of something like this.
Well, the logistics are, I don't have the authority to order law enforcement. I can certainly work in conjunction with them and refer matters to them. What they and how they investigate is their discretion. Obviously, if circumstances require it, prosecutors can go to court and seek court orders against any number of parties. But no, I can't actually order law enforcement.
Okay, so bottom line, you don't have too much disagreement with what went on, although you don't think it's necessary.
That is true.
All right, we'll stop it right there. It's good to have you both here. Thanks for joining us.
Thank you.
George Zimmerman is in the news again. He was arraigned today on charges of domestic violence. Zimmerman's killing of teenager Trayvon Martin this summer in Florida brought national attention to stand your ground laws, which shift the burden of justification for the use of deadly force to the state. Florida's stand your ground law was not specifically used in Zimmerman's defense, but the issue continues to divide those with differing views on the legal duty to evade or retreat from confrontation. A forum on Arizona's Stand Your Ground law will be held this Saturday at ASU's Sandra Day O'Connor College of Law. State Representative John Kavanaugh will be participating in the event, as will State Representative Martin Quesada. And good to have you both here on Arizona Horizon.
Always a pleasure.
Let's set some parameters here. What does Arizona's Stand Your Ground law do?
Arizona's Stand Your Ground law is a model for brevity in legislation. It's just really one paragraph, and I'll read it. A person has no duty to retreat before threatening or using deadly physical force pursuant to this section if the person is in a place where the person may legally be and is not engaged in an unlawful act. That's it in a nutshell.
And that's how you see it as well.
Well, it's certainly a brief statute, but it's more than just that. It's more than that. In a nutshell, this is encouraging people to engage in violent activity. This is encouraging people to engage in vigilantism, and especially in situations where there is no need to promote further violence. And that's what one of the big problems is with this law.
This has been described as shoot-first legislation. Respond to that, please.
Right. You can't understand Stand Your Ground without understanding the basic law of self-defense in Arizona and just about the entire country, because it's all pretty much the same. Stand Your Ground does not relieve a citizen of the necessity of complying with the basic law of self-defense. If they violate the basic law of self-defense, then Stand Your Ground means nothing, and they're going to be convicted of murder or manslaughter. So let's look at the actual law. When can a person use deadly force to defend themselves? The law is very simple. You have to have a reasonable belief that it is immediately necessary to use deadly force to defend yourself against somebody using unlawful deadly force against you. If you don't have the reasonable belief, if you can't prove it was immediately necessary to defend yourself, then you're finished. You are guilty of a crime. If you killed a person, it's murder or manslaughter. If you injure them, it's aggravated assault. And Stand Your Ground has no effect. But if you are in fact justified in using the deadly force, then what stand your ground does is it says you don't have to run away before using force. Because without stand your ground, you could be second guessed later by prosecutors who said, we think you could have run away and therefore you're guilty of murder.
Should someone who is facing this kind of confrontation have a duty to evade or, in the representative's words, run away?
Well, the question arises: what is the need for stand your ground if these self-defense laws are already in place? The self-defense laws do give you the ability to a person to defend themselves. What this stand your ground law does is it encourages that violence to occur. It ensures that violence is going to occur in situations where a violence could be avoided, and that's the situation. If violence can be avoided, why not avoid it?
The operational word is could. You don't know. Justice Oliver Wendell Holmes, Supreme Court Justice, summed up in a phrase why we need stand your ground. In 1921, in a case called Brown versus the U.S., where the Supreme Court upheld the no duty to retreat principle, he said, and I quote, "Detached reflection cannot be demanded in the presence of an uplifted knife." In other words, when you're in that tense situation, you're not in a position to sit and reflect on what you're doing. And I would add that today, it's not the uplifted knife that you may be facing. You may be facing a Glock 9mm with 15 rounds. It's too dangerous in many situations to pause to think, shall I run away?
But I think the argument on the other side is the lowering the threshold of using legal force means you're going to see more lethal force in situations that otherwise would not have presented themselves.
You're not lowering the threshold. You still have to meet those basic principles that I said, the reasonable belief, the immediate necessity. All you're saying with a stand your ground law is that you don't have to run away. And the reason for that is, if you had that requirement and the person thinks that they can't run away safely and they use deadly force, they can be second guessed later by a jury and then or a prosecutor, and they can wind up having to spend tens of thousands of dollars defending themselves in court.
The threat of the burden of proof on the person defending themselves seems to be a major aspect here. How do you see that?
Well, those protections are already in place with self-defense laws as they are in place in statute now. Again, what this comes down to is there are going to be situations where a person has a choice. They could stand and fight and incur violence, or they could retreat. This is going to give them the motivation to engage in that violent behavior. What that brings is the possibility for more victims rather than less. When a person decides to not engage in violent activity and retreat, seek shelter, find a safe place, the chances of serious injuries and death are decreased by that action.
The argument that this makes for a more dangerous community, the argument that this makes for a less, I'll start with you, and the argument that this helps secure communities. You buying that?
No. In fact, we have no research that shows that these stand your ground laws are effective at all. And that's why I think that these laws do need to be reviewed. We need to sit down, we need to take a look at them, see if these are promoting violence, if they are promoting safety in our communities, or if they're not having that effect at all. If they are not having that effect, are they having the opposite effect of promoting violence?
It's impossible to do. I've looked at the studies. Some studies say that stand your ground laws are good, some say they're bad. All the studies are fatally flawed because the data that record the shootings doesn't specify if stand your ground was an issue. So the researchers have to look at overall homicide and assault rates in states that have it and don't have it and try to say, well, if there are more homicides in a stand your ground state, then it encourages violence. But they can't control for all the other factors that are involved. And they can't determine whether if there are in fact extra homicides, whether they're justified. Because if they're legally justified homicides, there's nothing wrong with them. That's people saving their own lives against criminal attack.
But again, back to an earlier conversation here and the idea that this encourages engaging in conflict as opposed to avoiding it. Do you buy that argument?
No, I don't. You know why? Because the average person not only doesn't know the basic law of self-defense, they don't even know what stand your ground means. When they're confronted with a life and death situation, they basically say, what do I got to do to save myself? They're not thinking about a reasonable belief, immediate necessity. They're not thinking about stand your ground. They're thinking about saving their lives. So when you don't have a stand your ground law, then you wind up subjecting people who wind up having done the right thing to prosecution, potentially bankrupt them, because a prosecutor somewhere says, I think they might have been able to run away.
And Ted, that might have been true several years ago. But now, because of the situations like the Trayvon Martin situation in Florida, Stand Your Ground has been in the news all over the country. People are aware of this law, and the message that this law is giving them is to fight, is to engage in violent activity. And that has to have an effect on our community.
Without this law, though, I'm seeing both sides here, and I'm trying to figure out, where both sides are coming from. I'm trying to figure out, how did we get by without Stand Your Ground laws all these years? And the idea that self-defense laws were good enough. Were they not good enough?
Well, first of all, if you go back historically, right, there was no requirement to retreat in many states. I mean, Stand Your Ground law, the requirement to retreat outside of your home, that requirement was pretty much non-existent until the 1960s, when a research group called the American Law Institute promulgated what they called a model penal code to try to get consistency between states, and they slipped that in. But it's never been a popular principle that you have to retreat if safe to do so, because people recognize, like Justice Holmes did, that detached reflection can't be demanded in the presence of an uplifted knife. It's unreasonable to make people engage in that type of calculus in the split second. It could cost them their lives.
The chaos of the moment, is it wise to have someone have to think about these kinds of issues as opposed to doing whatever is necessary to defend themselves?
No, and we're not asking people to think in life and death situations. If it is a true life and death situation, self-defense laws provide people with the opportunity to defend themselves. Stand Your Ground laws, all they do is they promote a message to our community that violent behavior is the answer, is the preferred method of reacting with a life or death situation.
Stand Your Ground laws subject citizens to almost a type of double jeopardy. Even after they prove that they've met the requirements for self-defense, they can still be convicted if a prosecutor says, I think you could have run away in that situation. Hey, today people are facing Glocks, 9mm Glocks with 15 rounds. It's very rare that you can safely run away.
Well, with that in mind, how many instances are out there in which Stand Your Ground changed the nature of a case?
Probably very little in terms of the encounter, but it does stop people from being bankrupted by overzealous prosecutors who decide that maybe because of political pressure, like there was in the Zimmerman case, that they're going to prosecute this person claiming they could have run away.
But so this sounds more like politics then, as opposed to on-the-ground activity.
This is a protection from politics. When you have a Stand Your Ground law, you don't have to worry about a prosecutor succumbing to the mob screaming for blood because they claim that they didn't like the shooting.
It sounds like we're moving into the realm of what the prosecutor's office can and should do in these situations, as opposed to what the person should do in these situations.
Well, again, to assume that all prosecutors are acting in this unfavorable fashion, I think is really a little bit far-fetched.
I didn't assume that.
Prosecutors are going to prosecute criminals. They're going to prosecute crimes that are brought before the state. What this does is, and you hit the nail on the head, it's a political message. It's a political message to individuals that guns are the answer, violence is the answer, and shooting your way out of a situation is the preferred method.
Do you want to see Arizona Stand Your Ground law, do you want to see it removed completely, or can it be modified? Can the duties of the individual be changed in some respects?
At the very least, our law needs to be revisited and studied and evaluated. There are methods that we could do to make it better, and part of that review should be to look at other ways that we can improve that law.
Wise idea to revisit?
Well, it's always good to review, but we've been doing that since the Zimmerman case, and everything that I've seen says it's a good law. And I might add, this all came from England. In England, right, they don't need Stand Your Ground laws, because in England, that's part of the jury's overall deliberation in terms of whether this was reasonable or not. And that's the way it is here. You know, even though we have Stand Your Ground laws, if a jury says we think that person could easily have run, then they're going to say that there was no immediate threat, and they're going to convict the person.
Of course, that's to get to the jury in the first place, but that gets back to whether prosecutors just
right.
decide who's going to go in that direction.
And I want to clarify, I think only a few rogue prosecutors would succumb to the mob's quest that the person who defend themselves should be prosecuted and subject somebody unnecessarily to such prosecution. But you need a law like this for those few instances to protect decent people who defended themselves against unlawful aggression.
Actually, those prosecutors that are acting outside of the norm, there's an appeals process in our judicial system to handle those situations. So again, stand your ground laws not necessary.
Gentlemen, good to have you both here. Thanks for joining us.
Thank you.
Okay.
We want to hear from you. Submit your questions, comments, and concerns via email at arizonahorizon@asu.edu.
And Wednesday on Arizona Horizon, ASU physicist Lawrence Krauss discusses dark matter in his monthly update on Science News. And we'll hear about research to improve the efficiency of solar cells. That's tomorrow at 5:30 and 10 on the next Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.